Michigan Secretary Jocelyn Benson. She is now had asked for an opinion from the Attorney General, Dana Nessel. She can't say, I support your right to do this, because she can't, because it's not legal. And she can't say, I reject your request to do this, because then she'd be saying no to her BFF. I think that the administrative rules are obsolete. I don't like the administrative rules. I want to change them. What's your thought on that? And Dana has declined to provide her opinion. Very convenient. Michigan Secretary Jocelyn Benson changed the rules again. This time they're about the recount. We have not had the election completed yet. She's already thinking about what happens if it's too close to call. How can she finagle it in favor of Kamala? She is now had asked for an opinion from the Attorney General, Dana Nessel, and Nessel's office declined to give her advice on this. And what's so curious is that what that means is that if Dana Nessel won't give her advice and Jocelyn Benson has one interpretation, well, that means that Jocelyn Benson's interpretation will be the de facto interpretation, because the AG is not stepping in to correct the record. So not even going to weigh in, right? Can't say anything. Saying nothing is safer than saying anything. She can't say, I support your right to do this, because she can't, because it's not legal. And she can't say, I reject your request to do this, because then she'd be saying no to her BFF. So what she said, that she's decided against issuing an opinion. Isn't that incredible? So they can just change the recount rules. Here's what Jocelyn Benson sent over. She said, all right, dear Dana Nessel, and they're like the three amigos there in Michigan, Big Gretch Rona, Jocelyn Benson, and Dana Nessel, the AG, all BFFs, hate Trump, and Republicans, and I think white males, says, Dear Attorney General Nessel, this is coming from Jocelyn Benson's office. So watch what she does. She's going to change the rules here in real time and then deploy this all throughout the state. And she just did this October 23rd. This came out, she tried to hide all of this. This came out from a FOIA request that was obtained by FOIA Services Michigan. Finally cracked the lid on this. But here's what Jocelyn's doing. She says, okay, listen, Dana, I'm writing to request an opinion from your office about specific procedures that are related to recounts. Currently, I think that the administrative rules are obsolete. I'm asking about the procedure for recounting ballots at early voting locations and a denial of recount petitions that do not allege error in the counting of ballots, right? So tightening the rules. 1, I don't like the administrative rules. I want to change them. What's your thought on that? 2, when we do a recount of the ballots, I want to determine how to count them, how we do that, what the procedure is. And 3, I want to deny any recount petitions if they don't allege a certain thing. So she can stop fraudulent claims from reaching the next step. Says the recount process is governed by these laws. It was passed back in 1979. The law has been amended a few times, but now I seek your advice. These rules are obsolete. Says the current rules do not accurately describe modern tabulators. They were written a long time ago. They talk about shoot machines, and they discuss talking like the opening, like open the drawer and seal the drawer and all this. They don't even match. Those rules don't even match our rules. And so the current recount rules are also premised on other statutory provisions that are no longer in effect. You know, normally there's a process to change the rules. And she says, we haven't gotten answers or waiver requests. Says, I wanted to change the rules and get their permission to change the rules, but they're not allowing me to change the rules. So now I want your permission to change the rules, and I'm going to change the rules. What's your thought on it? Says, in apparent reference to this, it describes this. And so this is bad, right? All of these, she says, my position is that the rules that are clearly obsolete cannot be harmonized and must be disregarded during a recount. See that? She just is saying, look, I know there's a process in order to change the rules. The rule was set along with a letter and sent, but they haven't responded, and they're not going to respond within 15 days. And November 5th is coming up. It's 2 weeks away. And so I can't get this done in time. I have these problems that suddenly showed up. And so now I need your permission to change the rules. And as we saw, they're obsolete, and some of these things don't match. It could be misleading. It could be potentially confusing. And so I'm on my own, stepping outside of the proper process. My position is the rules that are obsolete cannot be harmonized and must be disregarded, right? She's just disregarding the rules. She said this other proposal was adopted that grants Michigan voters the right to participate in early voting. However, the amendments did not expressly address recounting of the ballots at early voting sites, nor do the current recount rules address this. And so the pending updated recount rules include a rule addressing early voting. However, as previously noted, it does not appear that the pending rules will be effective before this happens. Any recount of the November election will necessarily require recounting ballots at early voting sites. And so my position is, even though it's not a rule, is that the Michigan Constitution and election law generally treat early voting sites and election day precincts as basically the same, with necessary accommodations for the early voting sites. So you see what's happening here? There are election day recount rules for ballots cast on election day, and she wants to create resources for early voting sites. She knows election day sites are going to be major R, major Republican. So she wants, if there's going to be a recount, she wants to also be recounting and basically setting up the early voting sites as parallels to election day sites, because there'll be a lot of other ballots there. So let's move some resources to early voting sites and treat them the same as election day sites, even though those are not in the rules. Because there is currently no binding statute or rule expressly governing the ballots at the early sites, I request advice about procedures to recount ballots at early voting sites, even though the rules are kind of actually don't say much about it, about can you do that in early voting. And now we also have the scope of the recount, saying the pending recount rules also include a provision that clarifies the scope of a recount, specifically mandates rejection of a recount petition. So let's say someone says there's fraud, you file a petition, you says it's rejected if that petition does not allege an error in the counting of the ballots. I request advice on whether, even absent a rule, whether we can rely on the current law to reject a recount petition that alleges an error unrelated to the counting of votes. Right? If you're claiming fraud of one category, it doesn't count for a recount. You cannot do a recount unless it goes specifically to the counting of the votes. My position is, again, she just makes it up, is that the Michigan law do not allow for use of a recount proceeding to conduct a broad investigation of alleged fraud or mistake if it's not related to the number of votes cast. So if you have a general allegation of fraud in some way, no recounts allowed, which provides for a recount and sets the requirement. It says that an aggrieved party must be aggrieved in the canvass of the votes. She says, so I'm interpreting this to mean like in the specific numbers. Case law also supports this interpretation. And so you have to have a good faith belief that there's mistake or fraud, and you've got a reasonable chance of winning the election. Otherwise, if you believe that a mistake occurred because of fraud or because of error, the fraud or error must be in the counting of the ballots. Other mistakes, other frauds, other things don't matter. It must be in the counting of the ballots. So very, very narrowly interpreting the permissible scope of standing kind of for who can bring a fraud claim in Michigan. Says, in conclusion, I respectfully request your formal opinion regarding these three issues. And Dana has declined to provide her opinion. Very convenient. Says, I'm declining to do it. Our office's process for deliberating and answering opinions would make it impossible to answer these questions before the election. And so we're not going to issue an opinion after much deliberation and discussion. And so Jocelyn Benson just changes the rules right in the middle of the election on her own. No waiver, no due process. It was already pending. They didn't get it done in time. So she just comes out, writes a letter, changes a bunch of stuff. The bills failed to get enough Republican votes in the Senate. And so it's not going to take effect until 2025. The whole point of a recount is to make sure we're getting the most accurate count of ballots. Benson submitted the request to the rulemaking committee. Now, under the rules, the committee can take up the rules within 15 days or the rules are adopted by default is what they say. Now, the legislature, though, has not met for 15 session days since July, has not waived it, and is unlikely to do so. So that means that the legislature is not allowing this to move forward. So Jocelyn Benson just does it anyways. In Michigan, she lectures everybody about democracy and about stopping tyranny and tyrants. But then what she does is just ignores the legislature, ignores the process, ignores the rulemaking procedures, and just changes the rules unilaterally on her own. And then her best friend, Dana Nessel, at the AG's office, comes out and supports her doing that.